Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. This video will be useful for the CPC students. I think CPC students are lucky enough because the cases relating to the basic principles of CPC, they are being subjected and decisions are coming. Very recently, I have quoted the definition of Order 5, Rule 2, that is enclosing a full copy of the plaint. Likewise, debug, that is time bound rejection of plaint, Order 9, Rule 11, all these things we have been discussing. Another issue, that is res judicata. So, interest republica, ut sut finis litiam. In the interest of the state, in the interest of the republic, there should be an end to the litigation. This is the main principle behind res judicata. So, Supreme Court, two judges bench, Honorable Justice J.K. Maheshwari and K. Vishwanathan, in the case of Samir Kumar Mazumdar versus Union of India in criminal appeal number 6027 by 14 dated 29/2023. So 2014 criminal appeal is decided on 29/2023. They reiterated, please remember, they reiterated the established principle of res judicata. It is a universally accepted principle which was recognized in so many sensational cases decided by the Honorable Supreme Court of India. No party should be vexed twice in a litigation for one and the same cause of action. And that too, here in this case we are going to learn explanation for, that is constructive res judicata. Please remember, whenever the topic of constructive res judicata comes, you have to remember the very famous case of State of Uttar Pradesh versus Nawab Hussain 1977. Right, so let us go to the facts of the case first. Here the appellant, that is Samir Kumar Mazumdar, he was initially appointed as a substitute teacher. He was appointed as a substitute, just like in railways, you will be having a relieving station master. This is substitute teacher. Whenever the regular teacher is absent, maybe due to on maternity leave or something like that, this man will be appointed. So he will be taken as a substitute teacher on 5/12/1989. But it was not a continuous post. He was given breaks during intervals like Dasra holidays, Pongal holidays, and after the vacations. So he used to be removed before the holidays. After 1 month, he is again reinstated. That means there are breaks or intervals in his the employment. So he was given a retrenchment at the time of vacation and later reappointed. So ultimately, the last case he cited is he was terminated on 22/9/90, but once again reinstated on 1/11/1990. That is after almost 1 year, 1 month, 10 days. Therefore, he filed an application before the Central Administrative Tribunal because he was working in central government. So central government he has before the CAT, Central Administrative Tribunal, but which dismissed the petition. And High Court, he went, of course, to the High Court regularisation of service. Yes. Here, this important point is, what is the defense he has taken? That is more important. Here, the role of Section 11, explanation 4 comes. Constructive res judicata. What does it say? Please remember, constructive res judicata says, any matter which might and ought to have been, ground of defense or attack, it will be taken as issue. That means whatever ground defense you have to put, you put in the first instance, later it will not be taken. This is what happened. So he filed the petition before CAT Guwahati. That is what the prayer, that is important. The prayer is to set aside the so-called termination and regularization of his services and give the salary for even for the break periods also. Of course, as I told you, the CAT dismissed, then the matter came to the level of the Supreme Court. Supreme Court, in its wisdom, they disposed of the petition, observing that he may be considered for regular selection. So the option was given to the central government. Okay, they have actually president to service the orders, and he was appointed as a primary teacher in the railway higher secondary school, where the Bengali was the medium. Okay, yet there was an existing vacancy in the railway higher secondary school. He was posted there. But once again, he filed another application before the CLAT. Once again, Cyber Tribunal, Central Appeal Tribunal, Central Administrative Tribunal, Guwahati, right? That he should have been given the assistant teacher post, as he already worked as a substitute teacher and used to go to the class of 11th and 12th. Now he cannot work as a primary teacher. This is his second allegation. Now, CAT dismissed, High Court dismissed, ultimately Supreme Court. So once again, that man was dare enough to able to come to the Supreme Court. Supreme Court, so please, taking the advantage of or taking into consideration of so-called section 11, explanation 4, they clearly stated that when once you take up any defense or offense, you have to inform the same in your pleadings, but not piecemeal. So therefore, the regularization was mentioned, and the teacher, that is applicant, he never mentioned about the post, particularly whether he is a primary teacher, whether he is assistant teacher, school assistant, all these things he has not discussed. So civil cases, they don't go beyond the issues. Therefore, they were correct. Now, the Honorable Supreme Court of India cited a very famous case law, Henderson versus Henderson, 1843. In this, Sir James Wigram, he said that the court required the parties to bring the whole case and will not permit the same in piecemeal. So you have to, whether it is offense or defense, you have to enter in whole. So no plea was raised at the particular first point of time regarding the teachership, whether it is assistant teacher, substitute teacher, a primary assistant, all these things. So now you cannot raise the plea. It is barred by res judicata, interest republicae ut sut finis litiam. So please read the judgment and enrich your legal knowledge. Thank you very much.